Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And in the previous lecture, basically we had discussed the Article 20 and Article 21 in detail. About Article 20, basically we have seen the restrictions or applications. You can say restrictions on applications of the provisions. Okay. And basically we had discussed the Article 21 in detail, in which we had discussed the two famous cases, the Gopalan case and the Menga case. Okay. So I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. So here I am going to ask you the one simple question, like what was the year of Gopalan case and what was the year of Menka case? Okay. So now you are required to give me the answer of this and you have a time of 40 seconds. Sorry, 30 seconds, not 40. 40 will be too much. 30 seconds you have and your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20th, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically if we talk about it, so the Gopalan case was happened in the 1950 and the Menka case was happened in the 1978. Okay. Apart from the year, the second important thing is that in the Gopalan case, there was an narrow interpretation, and in 1978, there was an wider interpretation, okay, of the same article, which was the Article 21. Okay, so that is about the previous lecture, whatever we have discussed. Now, basically in this lecture, we are going to start from where we had left, and here we are going to see the fundamental right and the Article 21A. Okay, please do not get mixed with the Article 21. Article 21 is for the personal life and the liberty, while if we talk about the Article 21A, so it declares that it is the responsibility of the state to provide the free and the compulsory education to the children of the age of 6 to 14 years in a such a manner as the state may determine. Okay. And this is oftenly called as a elementary education. Got it? That's the thing. So basically here you can see one thing, like there is a right, okay, that every student who is in the age group of 6 to 14 is entitled to receive the free and the compulsory education from the state. But the manner in which the education will be provided, that is totally depend upon the state government. Okay, like here you can say the manner in which the state may determine. Okay, thus this provision makes only the elementary education or the initial education a fundamental right, and not a higher or the professional education. Okay, the higher or the professional education is not burden, or you can say not necessarily put as the responsibility on the state, so that they have to provide it. Okay, if we talk about this provision, so originally this provision was not presented in the fundamental rights. Okay, so if it was not presented, which means that it is later added. So if it was added, so there must be some amendment. Why? Because we know that the fundamental rights are the one of the basic structure. One of the basic structures, right? And we know to change the basic structures, the amendment is necessary. So if the system has been changed, it means that there must be some amendment. So the amendment was the 86th Constitutional Amendment Act of 2002. Okay, so it is very necessary that Article 21A is different, and basically it was not added previously, and it was added after the 86th Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve the education for all. Okay, the government described this step as the dawn of the second revolution in the chapter of citizens' right. Why? Because first, the entire, you can say, entire citizen rights, if you look at it, so basically they are moreover confined only on the political democracy. But here, if you talk about it, then it is totally upon the education. Okay, it means that the protection against the, you can say, the rights, sorry, arbitrary powers of the state is good. But what about the general welfare? All right, so that's the thing. And here, remember the one thing, that previously, it means that before adding as a fundamental right, that was available in the directive principles of state policy, where in the directive principle of state policy. Okay, remember this thing. Thereafter, if we move forward, even before this amendment, the Constitution contained the provision for the free and the compulsory education for children under Article 45, Part 4, okay, which stands for the DPSP, or known as Directive Principle of State Policy. However, being a directive principle, it was not enforceable by the court. Why? Because we know the provisions of DPSP are only just, you can say, given in the Constitution, and they are not enforceable by the courts. Okay, so there is no scope for the judicial intervention in this regard. It means that whether the government want to implement the education provisions for the children or not, this could not be challenged. But this amendment changed the subject matter of Article 45 in directive principles and basically provided it to as a fundamental right. Okay, so now we can say that it is become necessary that the students must get the education under this act. Okay, it now reads, the state shall have endeavored to provide the early childhood care and the education for all children until they complete the age of 6 years. Okay, also added a new fundamental duty under Article 51A. Okay, that reads, it shall be the duty of every citizen of India to provide the opportunities for education to his child or ward between the age of 6 and 14 years. Okay, it means that if we talk about it, elementary education, If we talk about it, then we could say basically it has been provided in three forms. First form is that the principles of state policy. Okay. Second form is fundamental rights. Third form is fundamental duties. Okay. And if we talk about the respective articles, here it is as in Article 45. Here it is as in Article 21A. And here it is an Article 51A. Okay. So that's the thing. So basically that was the year of 1993 when the Supreme Court recognized a fundamental right to the primary education is the right to life under the Article 21. And when we were discussing about the liberty provisions of the Article 21, basically we had encountered this thing there also. It held that every child or a citizen of this country has a right to free education until he completes the age of 14 years. Okay, like when the children is in the you can say elementary phase and not a teenager. Till then, it is the responsibility of the state that the free education must be provided. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. So that's why only the responsibility of the state has been defined, but the manner in which the state will provide education that is untouched by the provisions and that is totally depend upon the state's economic capacity and the development. Okay. In this judgment, the court overruled its earlier judgment of 1992, which declared that there was a fundamental right to education up to any level, including the professional education like the medicine and engineering. Okay. Like here, if we talk about it, then we know only the elementary education is promised. Okay. But in the 1992, the Supreme Court said not only the elementary education, but education up to any level. It means professional educations like the medicine, engineering, or you can say the higher studies. That all will be considered as a right to education. Okay. Thereafter, in pursuance of the Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act, which is famously known as the RTE. Okay. So now it is an important question from the examination point of view. The question may be asked you under Article 21A, which act the government has to enact in the 2009. So the name of the act is Right of Children to Free and Compulsory Education RTE Act 2009. This could be even reverse. That the question may be asked: Right of Children to Free and Compulsory Education RTE Act 2009 basically enacted under which of the following articles? Okay, so remember the article is 21A. Okay, and the options may be like suppose 45, 21, 21A, 51A. Okay. So if you haven't clarified your concept, then what will happen? You will get confused in these articles. Why? Because all these articles having the provision of right to education. Okay. That's the thing. But only the Article 21A will have the correct form if we require the particular act. So if we talk about this act, so this act seeks to provide that every child has a right to be provided the full-time elementary education of the satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Okay, it means that, however, however, the manner of providing education is free. Okay, but there are some certain essential norms and standards, and these must be satisfied. If these are not getting satisfied, what will happen? The aim of providing the satisfactory education to the child in the early age will not be, you can say, fulfilled. So that's why there is an act. This legislation is anchored in belief that the values of equality, social justice, and the democracy, and the creation of a just and human society can be achieved through the provision of inclusive elementary education to all. Why? Because if we talk about this age, so this is the basic foundation of human personality, right? This is the basic foundation of the human personality. So if in that stage the person is not getting enough to develop himself, then what will happen? He will not be so good in the developing in future. Okay, so that's why it is said these things. After this, after the 21A, now we have the Article 22, which stands for the protection against the arrest and detention. Okay, so the Article 22 grants protection to the persons who are arrested or detained. Okay, why? Because these are also known as the act of arresting or detaining someone is also known as executive actions. Okay, could be converted into the arbitrary executive actions, right? So to prevent the conversion of executive action into the arbitrary executive actions, the act is provided. Okay, but if we talk about detention, okay, the detention is generally defined in the two terms: punitive and the preventive. Okay, so these are the two terms of the detention which have been described here. If we talk about it in detail, so remember, the punitive, you can say, detention is to punish a person for an offense committed by him after trial and conviction in a court. Okay, for example, suppose that is the person who had committed something. Then what will happen? He will be arrested by the police. Okay, then what will happen? The police will present him to the court. Okay, and then what will happen? The court will trial and sentence him to the prison. or jail, right? So this is the normal procedure. Here is the arrest. Here is the, you can say, prosecution. Here is the sentenced. And then the jail. So if that process has been followed, then this is known as the punitive. It means that the person committed the crime, the police took the action by arresting him, then the police and the authorities gathered the, you can say, satisfactory evidences, and the evidences presented before the court. The court found out that the person who got arrested by the police was the conviction of that particular case. Then the court will give the sentence according to the law to him. Okay, so this is the punitive. After, if we talk about the preventive detention, on the other hand, it means the detention of a person without trial and the conviction by a court. Okay, it means that the person detained by the police and the case closed here only. No prosecution will happen, no trial will happen, and no sentence would be granted by the courts to send him to the jail. Okay, it means person arrested by the police and then sent to the detention center, and the trial and judicial proceedings were basically bypassed. All right. So if that particular thing happened, then the case called as a preventive detention. Okay. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in the near future. Okay. The purpose is not to punish a person for past offense, but to prevent him from the committing an offense in the near future. That is the thing. Okay. So preventive means, suppose if the some person committed something in 2001. So for this, the person could not be detained in 2006. Okay. If he got already convicted or sentenced or punished for the offense he had committed in 2001, then the person could not be arrested or detained again in 2006. But if he is planning that he will commit something in 2007, upcoming future, then to prevent that particular thing which is going to commit, he could be detained, and this is known as the preventive detention. It means the person already got detained by the authorities so that he could not commit any offense in the nearby future, so that the safety of others could be ensured. Thus, preventive detention is only a precautionary measure and based on suspicion. Okay, it means that it is not like the punitive one, in which the first the crime will committed, then the trial would happen, and then the official sentence would be granted by the courts. But in the preventive one, only the precaution measures will be taken on, and on the basis of suspicions, which means without having any, you can say, prevalent and the adequate certification or evidences, the person could be sent to the jail. Okay, so the Article 22 has two parts. First part deals with the case of ordinary law. Okay, it means that there is an ordinary process. The person committing the crime, then he is getting arrested by the authorities, then the trial is going on, and the person will be declared convicted officially, and the person will be sentenced to the jail by the judicial authorities. Okay, but if we talk about the second part, so second part is deals with the cases of preventive detention law. It means that the person did not commit anything. Okay, but because of the precautionary nature and because of the suspicion, that might be that person will commit something in the nearby future. The person will be detained. Okay, so that's the thing. The first part of Article 22 confers the following on a person who is arrested or detained under an ordinary law. Okay, like what is the process? As I have told you, if someone was arrested for the conviction of the things, then the person who is in the custody, and the custody will be temporary custody. Why? Because the person has not been sentenced by the judicial authorities so far. Okay, the person was only arrested so that the adequate evidences and the things could be collected against him, and the adequate you can say the information of the case could be gathered. All right, so basically that's why from temporary custody to the permanent conviction, there is a well-defined process which is required to be followed by the authorities. The first thing here is the right to be informed on the grounds of arrest. Okay, suppose if there is a Mr. X, okay, and he was arrested by the Haryana police, for example, then while arresting, it is a responsibility of the Haryana police that they are required to inform Mr. X that on which grounds he is getting arrested. Okay, like he has committed some criminal case, he has committed some civil case, or he has violated some act and all. Okay, these rights must be given to the person who is getting arrested. Second thing we could see here, right to consult and be defended by a legal practitioner. Okay, it means once the person, it means here in the case we have Mr. X. Okay, if the Mr. X detained by the police inform that on this grounds we are arresting you, then the Mr. X will get adequate chances so that he could consult and defend it himself with the help of legal practitioner. Okay, it means that he will get a chance to meet some legal practitioner. All right, thereafter, right to be produced before a magistrate within 24 hours, including the journey time. All right, so you can say, suppose if Mr. X was arrested on 8:30 p.m. 2nd January. Okay, so till 8:30 p.m. on 3rd January, which is the time period of 24 hours. Okay, within this time period, including the journey time, it means that from police station to the magistrate office, all this time will be included. Within 24 hours, he is required to produce before the magistrate because he has been arrested on the temporary grounds. Okay, and when the police will present him before the magistrate, the police will explain the magistrate on which grounds he has arrested, what was the crime, and how the police could, you can say, satisfy the procedure that Mr. X was the one who committed that particular crime. All right. Thereafter, right to be released after 24 hours unless the magistrate authorizes further detention. Okay. Suppose Mr. X was arrested and Haryana police presented it before the magistrate. But while the proceeding, the police got failed and could not explain that on which grounds the X was arrested, and even the police did not have the sufficient evidences to prove that Mr. X was a guilty. Okay. Then what will happen? The magistrate will pass the orders to release Mr. X. Okay. That's the thing. It means that if all this happens between the time period of 8:30 p.m. 2nd January to 8:30 p.m. 3rd January. So within this time period, Mr. X need to be released by the police authorities if the police getting failed to got the further detention or the custody by the magistrate for Mr. X. Alright, so that's the thing. Students, basically in this lecture we have covered till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.